Everyone, it's Ahmed. So on August 26th, the Supreme Court lifted or vacated the CDC-imposed eviction moratorium, and this is quite often being lauded as this major win for landlords. But is it? Is it really? And that's what I want to talk about in this video, is what are some of the challenges that continue to persist for landlords, even though the CDC imposed eviction moratorium has basically been lifted. In this video, I'm not going to go too far into it from a historical context perspective in terms of why was the eviction moratorium put in place, what have been some of the rulings and judgments to date. I've done videos on all of those topic areas in the past, and I'll include links to all of that in the description below. But before I get too far into this, don't forget to smash that like button for the YouTube algorithm, subscribe to the channel, and ring that notification bell, and let's get into it. So the Supreme Court opinion is basically the 16-page document, this document that basically talks about the many reasons in terms of why the Supreme Court views the CDC-imposed eviction moratorium to basically exceed the authority of the CDC. It, of course, cites other court cases that basically sets a significant amount of precedent, and this is about half of the document, and the remaining half of the document basically covers off on how the dissenting judges, because there were a few of those, and what their thoughts were in terms of why the eviction moratorium should perhaps not be lifted, and it effectively is within the authority of the CDC. But with that said, this was a 6-3 judgment, 6 Supreme Court justices out of the 9 basically supporting the vacation of the eviction moratorium, and 3 dissenting judges. Now, this report, for all intents and purposes, is relatively scathing, okay? It talks about various things and it points a lot of fingers. So all the screenshots that I show in this video are basically directly from this opinion, okay? And I thought it would be sort of refreshing to provide input in this video directly from source documentation as opposed to perhaps potential views from other media outlets. So one of the things that it talks about in this opinion is how Congress has effectively failed to act to increase the powers of the CDC such that they could legitimately impose the CDC eviction moratorium. In the opinion, it specifically states it would be one thing if Congress had specifically authorized the action that the CDC has taken, but that has not happened. Instead, the CDC has imposed a nationwide moratorium on evictions in reliance on decade-old statute that authorizes it to implement measures like fumigation and pest extermination. It strains credulity and to believe that this statute grants the CDC the sweeping authority that it asserts. The Chief Justices also have explained in this opinion how previously they had already viewed the CDC-imposed eviction moratorium under the original eviction moratorium to already be sort of like out of the bounds of the CDC, but they had not vacated the CDC-imposed eviction moratorium at that point in time because it only had a few more weeks to run. But needless to say, the Chief Justices were rather disappointed that the CDC did continue to impose this new eviction moratorium, and have stated in this opinion that apart from slightly narrowing the geographic scope, the new moratorium is indistinguishable from the old. Further, the opinion also states, we expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. The opinion gets even more scathing at that point. It states the moratorium has put the applicant, along with millions of landlords across the country, at risk of irreparable harm by depriving them of rent payments with no guarantee of eventual recovery. Further, it goes on to state, since the district court entered its stay, the government has had 3 additional months to distribute rental assistance funds to help ease the transition away from the moratorium. Whatever interest the government has in maintaining the moratorium's original end date to ensure the orderly administration of those programs has since diminished, and Congress was on notice that a further extension would almost surely require new legislation, yet it failed to act in the several weeks leading up to the moratorium's expiration. So needless to say, this may be viewed as a significant win when it comes to landlords and perhaps some semblance of justice in the landlord's eyes. But is that really the case? Well, it kind of partially, sort of, is a win, but it's not necessarily a win for all, okay? And what I mean by that is there are still state-imposed eviction moratoriums, and lifting this CDC eviction moratorium does not lift any of the state-imposed eviction moratoriums. And currently, at least based on some of the research that I was doing for this video, there are state-imposed eviction moratoriums in California, Illinois, Minnesota, New York, New Jersey, New Mexico, Washington, and Washington, D.C. And these are all significant population hubs with a significant amount of landlord-tenant relationships. Now, the CDC imposed eviction moratorium has absolutely no bearing on these state-imposed eviction moratoriums because the CDC, for all intents and purposes, does not have any authority on these whole landlord-to-tenant relationships, but the states arguably do so. And none of these courts for these states have basically overturned any of these decisions or laws made by the states. So in these states, the landlords are going to have to continue to deal with it. And I know majority of these issues are being faced by mom and pop type of landlords who effectively have lots of bills to pay and are not getting any cash inflow as it relates to rent. But those mom and pop type of landlords will unfortunately have to continue to bear the circumstances of these state-imposed eviction moratoriums. Now, understandably, since the CDC-imposed eviction moratorium has been lifted, perhaps the governors will perhaps think twice before they extend their own state-imposed eviction moratoriums even further, but that is definitely not a done deal, right? So when it comes to mom-and-pop landlords, landlord associations, and a lot of the states that I basically described, it's probably pertinent to continue to file motions with the court system in those states to overturn a lot of these, and also arguably when it comes to landlords to continue to talk to their aldermen or whatever representative that they have in their state to continue to communicate the challenges which they're basically facing. Additionally, when it comes to a lot of these types of states, it's also beneficial for the landlords to continue to keep that conversation open with the tenants such that the tenants can effectively support the landlords in terms of filing a lot of these documentation such that the states can provide them with some funding. But of course, the challenge continues to be that in a lot of these cases, the landlords and the tenants are absolutely hating on each other, and this relationship continues to get more strained on a weekly basis. So unfortunately, the likelihood of these tenants basically cooperating with the landlords such that the landlords can receive any of these funds continues to deteriorate, and we're going to continue to see articles in the media which basically talks about how people are basically surprised, or how government agencies are basically surprised that a lot of the funds that have been allocated by the federal government are essentially not making their ways into tenants as well as landlord pockets. Obtaining these federal funds is the benefit for both landlords as well as tenants. From a landlord perspective, it allows them to maintain their properties, it allows them to pay their bills, and of course it prevents the risk from them having to significantly increase rent on a go-forward basis to help absorb some of this risk. And of course, when it comes to tenants, it's beneficial for them as well because they'll have better maintained properties and they perhaps won't have to deal with higher rents on a go-forward basis. And of course, they're also meeting their obligation when it comes to that lease agreement which they signed when they first entered the property. Anyway, what are your thoughts as it relates to this whole saga on property rights infringement? Definitely include all of that in the comments below. I hope you found some value to this video. Don't forget to like and subscribe, and I will see you in the next one.